My name is Mara Collins, I'm 32 and 3 days after we buried my father I learned grief and paperwork arrive in the same envelope. I live in Bloomington, Indiana, where my job as a high school counselor has trained me to keep my voice level when rooms are drowning. Dad taught me a different kind of steadiness, how to hold a flashlight while he tightened a belt on a mill, how to listen for the clean note when a machine is finally aligned. He owned Collins Tool and Die, a stubborn little shop that built precision parts for people who still believed in fixing things. He also owned a weathered cabin on Lake Winona, a square of water that remembers the first fish you caught even when you don't. Dad married Denise 6 years ago. She is the kind of woman who calls a casserole a hot dish, like she invented ovens, who can make sympathy sound like a performance review. At the funeral reception, while people were still balancing paper plates and trying to say kindness without sobbing, she stood in the living room and tapped a folder against her manicured palm. "We'll keep this simple," she said, like the universe had asked for her leadership. Richard updated his plan. "I'm the successor trustee. We'll do a small estate process. No need for probate drama." She glanced at my brother Evan and me with what passed for warmth. "You'll be taken care of." I have a small degree in reading the space around words. Small estate echoed in my head with the wrong kind of light. Dad didn't do small. He did exact. He and I had sat at the kitchen table 2 summers ago with a binder he labeled I in case of rain. He walked me through his pour-over will, his revocable trust, the pod beneficiaries on his bank CDs, and a transfer on death deed for the cabin because he said, if anything tries to tangle that place, the deed will cut it loose. I remember the blue border on the copy and the way he smiled when he said my name and Evan's in the same sentence as the cabin. It had felt like a blessing that didn't need witnesses. At the house after the service, Denise opened the folder and slid out a stapled stack. Third Amendment to the Collins Family Trust. The date at the top was 3 weeks ago. Dad had been under hospice then, morphine steady, joke softer. The amendment named Denise as sole residuary beneficiary and gave her full discretion over all assets, with a short paragraph offering Evan tools of sentimental value, and me selected personal effects. The signatures looked like Dad's if you didn't know his hands. The notary seal read Harold Keyes, the neighbor who is fussy about everything, especially his notary log. My stomach said, "You're looking at a hall of mirrors." "We'll need the originals," I said. "And the binder." Denise's smile tightened. "I have the important papers. Let's not make this adversarial." Evan, who has never developed a taste for arguments that last longer than a song, folded his arms and stared at the carpet because it was either that or start a fight our grandmother would haunt us for. I put on my counselor voice. "We'll help. Monday morning I'm going to the recorder's office and the bank. We'll pull what's recorded and check beneficiaries. Clean, quick, kind." Denise folded the papers like she was tucking a child into bed. "Of course," she said. "We're all family." Monday morning the courthouse smelled like old paper and confidence. Evelyn Marsh, the deputy at the recorder's office, asked for the parcel number to the cabin and typed like the keyboard owed her money. The screen filled with instrument numbers, a ladder of our family's decisions. In the middle, 2019-043187, transfer on death deed, grantor. Richard Collins, grantees. Evan Collins and Mara Collins, joint tenants with survivorship, effective on death of grantor. It was recorded, stamped, and as real as a door. I asked for a certified copy. Evelyn fed the paper into a machine that sounded like it graduated from the same high school as my father. While it hummed, I asked about any revocations or later deeds. She scrolled and shook her head. "No recorded revocation," she said. "There is a quitclaim from last week though. Successor trustee Denise Collins to Denise Collins, an attempt to deed the cabin into the trust retroactively. Recorded after the grantor's death." She slid the printout across. "TOD deeds vest on death. If that's in place, this quitclaim is aspirational." The certified copy of the TOD deed landed on the counter with the weight of a promise kept. I took a photo of the recording number and texted it to Evan with 2 words. "We're on title." He responded with the emoji that looks like someone exhaling for the first time in a month. At the bank, a young compliance rep named Meena Patel led me to a small room with polite art and cold chairs. I handed her my driver's license, Dad's death certificate, and the copy of his binder page listing the bank CDs with pod tags. She tapped, frowned, then brightened. "Yes," she said. 2 CDs with payable on death beneficiaries, Evan and Mara Collins. Those transfer outside of the trust upon presentation of a death certificate. Will open claim files. No action from the trustee is required. Denise called it her job to consolidate, I said neutral. Mina smiled in the way people smile when policy has their back. We'll take care of the pods for you, she said. If anyone attempts to withdraw contrary to the designation, it will flag. She slid 2 forms across. Sign and we'll start. The same afternoon I walked up the block to Harold Key's place because his notary seal had been on the Third Amendment. He opened the door in socks and the kind of patience you develop by insisting people sign in blue ink. I offered condolences and oat raisin cookies. He invited me in, accepted a cookie, and listened without interrupting while I told him what I'd seen. Date? He asked, reaching for a small black book with gold edges, the notary journal he babies. 3 weeks ago, I said. He licked his thumb, flipped pages, and ran a line under a Friday where he'd notarized a power of attorney for a couple I didn't know. He turned the page. Monday, 2 affidavits. Wednesday, a lost title. I was in Carmel visiting my daughter the rest of that week, he said halfway to himself. No entries. No house calls. If my stamp is on something dated then, it wasn't under my hand. He looked up, eyes suddenly younger. I'll give you a sworn statement, he said, voice flat. Not because I enjoy the mess. Because the log is the log. Back at the house, Denise had spread papers across the dining table like a magician displaying cards. We need signatures for a family settlement, she said, pen poised. It's routine. We all agree not to contest the trust or amendments. I consolidate assets. You receive a generous distribution now instead of waiting. Waiting for what? Evan asked. For probate, she said as if the word were a disease. Which we can avoid. I set the TOD deed on the table face up so the stamp showed like a badge. The cabin passes to us by statute, I said, keeping my tone level. It's recorded. That property isn't part of the trust. She didn't look at it. Your father wanted simplicity, she said. The cabin is part of the whole picture. We'll use it to secure the home equity line and clean up the shop debt. Then we can. No, I said, and felt how calm that word can be when you've put a floor under it. The cabin is outside the trust. The CDs with pod are outside. We'll move those through their channels. For the rest, we'll work with counsel. Her mouth flattened. Counsel, she repeated as if I had suggested a tarantula. That night I took the iron case of rain binder from Dad's office where Denise had parked it like a prop. It was lighter than memory said, but the bones held. The original trust, 2017, amended once in 2019, named Denise as trustee only after Dad, with Mara and Evan as equal residuary beneficiaries after a specific life estate for Denise in the marital home and a directive to keep the shop operating or sell to Evan at a favorable note. The Third Amendment, Denise had waived, would wipe most of that. My body, trained by teenagers and a lifetime of Sunday dinners, recognized the taste of pressure. I called Alicia Gomez, the estate attorney a colleague had once described as a metronome in human form. She met me the next morning in an office with tidy plants and a view of a parking lot that made me feel safe for no good reason. I'll be plain, she said after I told the story, once with my throat and once with the binder. We need to slow this down. First, we file a caveat, a will/trust contest notice, so nothing moves without the court seeing it. Then we file to remove Denise as personal representative of the estate if she's filed anything there, and to compel a trust accounting if she's acting as trustee. We'll freeze dispositions. Meanwhile, that T-deed vests title in you and your brother. Good. The pod CDs transfer. Also good. Now the amendment. We'll test capacity and undue influence. I'll subpoena the hospice meds chart for the week of that date and the notary log. If the notary says he didn't perform the act, that's significant. What if she used a POA before he died to move things? I asked, thinking of the sudden emptiness in the brokerage folder. Then we seek a constructive trust over assets wrongfully transferred and request surcharge. That's a repayment plus costs. But keep your language clean. We don't accuse, we document. I exhaled and slid a page toward her I hadn't shown Denise. A photocopy from Dad's binder, his handwriting in blue at the top. Cabin recorded. Pods, leave as is. No changes without both kids present. I had found it tucked behind a warranty deed like a person who believed in belts and suspenders. Alicia smiled with her eyes more than her mouth. Your father meant to be understood, she said. Let's help him finish that. We left her office with a to-do list that felt less like battle and more like choreography. File caveat, serve notice, request accounting, order hospice records, get Harold's sworn statement, request DocuSign envelope metadata if the amendment was electronic, and quietly visit the safe deposit box to inventory any originals Denise hadn't paraded. The hospice nurse, Joy Randall, met me at the kitchen table a day later with a folder and the kind of gentleness people mistake for softness. She had Dad's consent form, the MAR, medication administration record, and her progress notes. The date on that amendment, I said. What was his status? She read. He was on scheduled morphine and lorazepam PRN for agitation. At 10 a.m. he was somnolent, arousable to voice, oriented to person but not to time. At 2 p.m. deepened sedation. At 5 p.m. unresponsive for sustained periods, family notified. She looked up. I'm not a lawyer. But I wouldn't have let him sign a field trip permission slip that day. Would you put that in a statement? I asked. Of course, she said. I document because people forget. Harold came through too. He typed his affidavit on a manual typewriter that left each letter slightly too proud, swore it before a different notary for hygiene, and handed me a copy of the log page for the week in question. The line where his stamp allegedly met Dad's signature was a blank day bordered by his daughter's birthday in Carmel and a dented grocery list. When Alicia filed the caveat and the temporary restraining order to prevent distributions, Denise responded with speed that felt like anger wearing a fancier coat. She emailed Evan at midnight. You're letting your sister turn this into a circus. Your father trusted me. Sign the settlement. We can be done. Evan forwarded it to me and then called to say nothing for a long minute, which is his way of not crying. We're not making a circus, I said. We're putting up railings. 2 days later, Evelyn at the recorder rang me. FI, she said, voice as calm as an ink pad. Someone tried to record a revocation of TOD today signed by Richard Collins dated last month. Our system flagged the date because the grantor is deceased. We rejected it. Thought you'd want to know who's trying to rearrange history. Who brought it in? I asked even though I knew. Courier, she said. But the contact on the cover letter was Denise Collins, trustee. After I hung up, I sat in my car outside the courthouse and stared at the TOD deed copy on the passenger seat. Recorded. Stamped. Instrument number like a phone number that always picks up. The part of me that takes care of other people wanted to turn this into a misunderstanding we could all laugh about someday. The part of me that had watched Dad teach a machine to sing knew better. You don't call a misalignment a melody. That night, I found one more thing I hadn't had the breath to look for yet. In Dad's desk, under the drawer liner where he kept stamps and the good pen, he had taped an index card in crooked blue. Mara/Evan. If you're reading this, I'm gone. Don't let anyone rush you. The cabin is yours by two. The CDs are pa to you. The shop belongs to work. Keep it or sell it fair to Evan. Denise has a home here for her life. That's decent. But the rest wasn't meant to be a shopping spree. Use the paper. Love fit. I took a photo and sent it to Alicia with the subject line intent in plain English. She wrote back, good. We'll keep it out of the shouting and in the file. By the time Judge Larkin set a date to hear our temporary orders, our pile was neat and heavy. TOD deed certified. POD claims filed. Hospice chart showing sedation on the amendment date. Harold's affidavit and log. Evelyn's rejection of the TOD revocation. And Alicia's clean motions asking for accountings and removal if Denise kept acting like trustee of things that weren't in trust. Denise tried one more press the night before the hearing. She caught me in the driveway with a look that had sold people on worse plans. This doesn't have to be hostile, she said. You're young. Take $50,000 each now and let me handle the rest. I'll make sure you get the house for holidays. Your father wanted me secure. He would hate this. I thought about Dad's hands, the small crescent scars where the mill bit talked back. The way he'd say simple is not the same as easy. I thought about Joy's chart and Harold's log and Evelyn's stamp and Alicia's commas and the deed like a fence post you can rest a world on. No, I said not unkindly. We'll let the paper do what he set it up to do. She shook her head like I was the disappointment and walked away. The next morning when we stepped into probate, the courtroom smelled like wood polish and morning coffee. Judge Larkin looked over his glasses and said the thing I had been waiting to hear someone say out loud. We are going to do this the right way. And I realized something simple and enormous. I hadn't come for a fight. I'd come for a process. The trap only worked if we forgot which side of the glass we were on. We were about to flip it. Probate at 9 a.m. looked nothing like TV. No mahogany thunder, just a room with scuffed benches and a clock that ran 5 minutes fast. Judge Larkin read our filings without commentary for a long 2 minutes, then set his glasses on the bench like a gavel that didn't need noise. Counsel, he said to Alicia, your caveat and temporary restraining order are before me. Any opposition? Denise had come in a cream suit and a new lawyer who introduced himself as Mr. Blake, a man whose haircut cost more than my car's last repair. He rose with practiced concern. Your Honor, this is grief, not fraud. My client is the widow. The trust was amended. Allegedly, the judge said, soft enough to pass for kindness. Where are the originals? Blake glanced at Denise. Denise looked at her bag like it might hatch a better answer. In safekeeping, he said. Bring them, the judge said. Today if possible. We don't probate out of purses. Here's what we're going to do. Temporary injunction. No distributions. No sales. No account closures. Produce a full inventory and accounting within 14 days. Turn over originals of the will, trust, and the supposed amendment to petitioner's counsel to be scanned and examined, with chain of custody. Petitioners have shown a colorable claim as to capacity and undue influence. I'm also appointing a special administrator, neutral, to preserve estate assets pending resolution. We will set an evidentiary hearing on the amendment. He turned to Alicia. Subpoenas for the hospice chart and notary log are authorized. Anything else? 2 more items, Your Honor, Alicia said, unbothered by the clock. We've presented a transfer on death deed for the lake cabin and pod designations for 2 CDs. We ask the court to recognize those transfers occur outside the trust and estate. Recognized, the judge said, already writing. TOD vests on death, pods pay by statute. If someone has tried to interfere with those, stop it. He nodded at Blake. Don't test me. Denise made a sound in her throat I'd heard before, when a plan hits a wall that won't move. Outside, Evan hugged me with his whole rib cage. You didn't even blink, he whispered. I practiced not blinking in front of 9th graders who lie about hall passes, I said, and it almost made us laugh. By noon, Alicia had couriered the judge's orders to the bank, the brokerage, and the auction house that Denise had quietly hired to liquidate Dad's shop equipment. The auctioneer called to say he'd hold everything until the court told him different, which is rural, for I've seen this movie and I want no part of Act 2. Denise surrendered the originals at Alicia's office at 3:17 p.m., processing it like a dental procedure. Alicia logged them the way museum people move paintings. Gloves, photos, envelopes, labels. The third amendment was there. 12 pages, crisp paper, cut and paste font that didn't match earlier amendments, and a notary stamp from Harold Keyes in an inky black Harold doesn't own. Chain started, Alicia said, sliding the envelope into a banker's box. Let's see what the facts want to be when they grow up. Facts grew quickly. Nurse Joy delivered the MAR and her progress notes under seal. Harold appeared with a fresh-pressed shirt and a sworn affidavit and attached photocopies of his notary journal for the week in question, empty where Denise claimed he'd been. Alicia's paralegal, Megan, requested metadata for the amendment, a document properties report from Denise's laptop, and because Blake let slip the word DocuSign, a certificate of completion for any electronic envelope. 2 days later, the DocuSign reply arrived. No record of an envelope on that date. When Megan examined the PDF, its properties showed it had been created by Denise C. at 10:42 p.m., 2 days after the notarized date, scanned from a Canon office device. The header from the scanner betrayed Denise's firm name. It felt less like a smoking gun and more like a stoplight turning red. Meanwhile, the bank compliance team finished their review of the weeks before Dad died. They flagged 2 transfers from a newly opened Collins Family Trust, amended, account that Denise had created using a pre-death POA, $18,400 to a Whitestone Interiors card, Home Refresh. Denise had written in the memo, and $12,600 to S. Corbett Consulting, her sister. They also flagged a debit 2 days after Dad's time of death, a cashier's check for $9,000 to cash. The bank reversed the post-death transaction, POA terminates on death, froze the POA account, and sent Alicia a letter volunteering records if subpoenaed. It read like a person who wanted to be a witness without quite saying it. I put everything in the binder I'd started to call Register of Truth out loud, partly as a joke, partly as a steadying ritual. Tabs multiplied. Orders TOD/pod, Amendment Forensics, Notary, Hospice, Bank, Shop, Communications. The weight grew honest. Blake pushed where he could. He filed a motion to quash the hospice subpoena on privacy, and an objection to Harold's affidavit as self-serving. Judge Larkin denied both in the same afternoon. Privacy yields to capacity, he wrote in tidy ink. As to the notary, the log is the log. When Denise realized the cabin had vested in us by TOD, she tried to pivot to access. No keys, no records. I drove to Evelyn at the recorder, who had already anticipated the next mischief and handed me a certified copy of the TOD deed plus the old warranty deed noting Dad's name. "Title's yours," she said. "This will keep locksmiths and law enforcement comfortable." It did. Deputy Ortiz from the county met us at the cabin, witnessed the rekey, took a photo of the deed and told us to call if anyone tried to negotiate with crowbars. We walked the dock Dad had sanded one 4th of July in the little kitchen that still smelled like outboard gas and coffee. Evan put his hand flat on the table and closed his eyes. "Feels like a voice memo," he said. "Play it again," I said, which is not what grief does but what it feels like it ought to do. Back in town, Alicia proposed a route I would never have thought to name. Mediation, but with the swords arranged so that the safe path ran through Denise, not around her. "The original trust has a no-contest clause," Alicia said. "An in terrorem provision. If any beneficiary contests the trust, they forfeit their share. Denise has been waiving the Third Amendment, like it erases the original. But if the court rejects that amendment and we're back under the 2019 trust, then pushing the amendment is functionally a contest of the original instrument. She risks her share, the life estate in the home and the elective pieces your father wanted her to have, if she keeps going. Will the judge enforce a no-contest clause?" I asked. "He'll enforce it if he finds bad faith and no probable cause," Alicia said. "Your stack, hospice sedation, notary log, scanner metadata, post-death POA, is not probable cause. It's probable misbehavior. We take this to mediation with a simple offer. Revert to the original plan, accept a surcharge for the POA misuse, make a constructive trust over anything she shifted, and we will not ask the court to enforce full forfeiture. She keeps exactly what your father intended, the life estate in the house, the elective share he anticipated. But if she refuses and loses at hearing, we reserve the right to seek enforcement of the no-contest clause and attorney's fees." "What's a surcharge feel like to a person?" Evan asked from his chair, grease under his nails even now. "Like writing a check to the truth," Alicia said. We set mediation for a Thursday at a neutral office that had learned to paint its conference rooms a color named peace. 2 days before, Blake tried a late play. He emailed Alicia a global settlement that boiled down to $50,000 each now, cabin deeded into trust, no contest, broad releases, no accounting. Alicia sent back an answer that read like a scalpel. Declined. Todd and Pods are not bargaining chips. Provide the accounting you are under order to provide. See you Thursday. The day before mediation, Megan finished a side project that gave me goosebumps where I didn't know I had skin. A signature analysis. Not a forensic lab, just a careful overlay of Dad's signatures from before hospice and the amendment he allegedly signed during it. She printed them on transparency sheets and laid them on the light box. The amendment signature tracked an earlier one almost stroke for stroke, including a tiny hesitation mark over the O, that an organic hand never reproduces exactly. "This is traced," Megan said quietly. "Or at least copied. It wouldn't be the only proof. It didn't need to be. It was the kind of detail judges love because it behaves like a sermon while staying a fact." Mediation day began with coffee that tasted like compliance. The mediator, retired Judge Hahn, set ground rules we didn't need and looked at both sides like a grandfather who decided to like you anyway. We started in the same room. Alicia spoke for us. Brief, boring, lethal. Petitioners accept the 2019 trust. They accept Denise's life estate in the marital home as written. They seek 1. Disallowance of the purported Third Amendment for lack of capacity and undue influence. 2. Surcharge of $31,000 for POA misuse. 3. Imposition of a constructive trust over any assets moved pre-death to a new, amended trust account. 4. Removal of Denise as personal representative and appointment of a neutral. 5. Fees shifted if we have to try this. If Denise agrees, petitioners will not pursue forfeiture under the no contest clause, and we will jointly issue a neutral statement honoring Richard's intent. Blake cleared his throat the way people do when they need more words than they have. This is punitive, he said. My client is grieving. The mediator lifted a palm. Everybody is grieving. What matters is paper. We broke into separate rooms. An hour passed. At noon, the mediator came in with that expression professionals wear when a case has reached its math. They will accept the original trust, he said. They will agree to the constructive trust and to a partial surcharge, $24,000, if you will waive fees. Alicia shook her head. 31 is not a decoration. It's a ledger. And we'll set the hearing tomorrow if we have to. Another hour. The hospice chart did its work without raising its voice. Harold's log sat on the table like a fence post. Megan's signature overlay glowed faintly on the light box we brought because Alicia plans like she expects to win. The mediator returned, looked at me first and said, they accept your numbers. They want one thing, a mutual non-disparagement clause. I looked at Alicia, she looked at me. We don't need to disparage anyone, I said. We'll tell our story to the court file and to our own heads. That's enough. We signed terms that afternoon. Amendment withdrawn and adjudged void by consent. Denise removed as PR, a neutral administrator appointed. Accounting due within 30 days. Constructive trust imposed on the POA account. Surcharge of $31,000 payable in 2 installments. No criminal referrals by either side, not my first choice, but Alicia said it keeps courts friendly. No contest clause not triggered so long as Denise performs. Todd Cabin confirmed vested in us. Pod CDs paid to us. The shop would be handled per the 2019 trust. Evan to have the first right to purchase the business assets at a favorable note set by an agreed appraiser. Denise's life estate in the marital home affirmed, with taxes and insurance her responsibility, as Dad wrote. When we walked out, the winter air felt 2 sizes larger. That's it. Evan asked the way people ask after surgery, hope threaded through disbelief. Almost, Alicia said. One more thing, the judge still needs to enter the orders. And I want the amendment ruled void on the record with findings, not just by agreement. It matters for the kind of memory paper has. That one more thing turned out to matter the next morning when Blake tried a small, predictable backstep, proposing clarifying language that would have let Denise reinterpret parts of the original trust later. Judge Larkin read our consent terms, listened to 3 sentences of dance and then said, "Stop. You don't amend with a wink." He signed orders with findings. The amendment was invalid by lack of capacity and undue influence. Denise was removed, surcharge approved, constructive trust imposed, TOD/pod confirmed, neutral administrator appointed. He wrote plainly, no flourishes, for future readers who would need clarity more than drama. We didn't do victory laps. We went to work. At the shop, Evan met with the appraiser and the neutral admin. We found wrenches that still remembered our father's hands and a coffee can full of bolts labeled, "Only if you're desperate," in Dad's printing. Evan ran his palm over the lathe and said, "I can make this sing," and the admin said, "Then you should," and wrote it down. We sketched a note that wouldn't drown him. 10 years gentle interest collateralized by the machines themselves and a life insurance policy Evan already had because our family believes in not leaving messes. At the house, I helped Denise gather her documents for the life estate. Tax bills, insurance declarations. It was as awkward as you're imagining and kinder than I expected. She looked smaller, like the version of herself without the armor of a scheme. At the doorway she paused. "I thought he meant me to have it," she said to the floor. "He meant you to have part of it," I said, not cruel. "He wrote it down." She nodded, which is not the same as agreeing, and closed the door. The cabin needed work, the kind of work that holds your head together. Recocking windows, sanding a splintered step, replacing a rotten board under the sink. Evan and I made a list and divided it like kids who had finally learned to share. I slept there one night alone, the lake doing its midnight breathing, and woke before dawn to a sound I will spend the rest of my life trying to deserve. Wind and tamarack loon farther out, the house settling like a body that trusts the bed. A week later, Alicia called with the best kind of administrative news. Order is docketed. Certified copies ready. The file will read clean to anyone who looks 10 years from now. She paused. You did this the hard way. Which is to say the right way. My throat warmed the way it does when truth walks in without knocking. My dad left us the map, I said. We just followed the signs he posted. We sent thank you notes like people who mean it. To Nurse Joy for writing things that hurt to write. To Harold for worshipping his logbook the way some people worship hymns. To Evelyn for guarding stamps like gates. To Deputy Ortiz for showing up with a quiet spine. I took Mina at the bank a box of donuts and she said compliance likes apple fritters best, which I will remember forever. There were late ripples. A cousin texted to say Denise had complained we'd robbed her. I typed we followed the paperwork and put my phone away like a grown-up. A neighbor asked whether we were pursuing charges. I said we're pursuing boundary lines. Sometimes revenge is letting the right fence stand exactly where the plat says it goes. The day Evan signed the note to buy the shop equipment, the neutral admin shook his hand the way men used to in photographs. Make something that lasts, he said, and Evan said, that's the idea. That night at the cabin we spread Dad's old tackle boxes on the table and threw out 3 pounds of rust the lake didn't need. In the bottom of a green tin, under a tangle of jigs, I found a folded index card in the same crooked blue as the one in his desk. If you're arguing, read what we wrote. If they're loud, find a judge. If you're tired, go to the water. Dad, I set it next to the certified TOD deed. I have never loved a still life so much. We weren't done. Alicia still had to file a final account with the court once Denise's surcharge cleared. And Evan had to pass a fire inspection at the shop because machines don't care about poetry. But the geometry had changed. The trap Denise set, the rushed family agreement, the staged signatures, the fake gravity of simple, had been flipped on its hinge and turned into a door we walked through. The last thing on Alicia's list was a line that felt ceremonial more than legal. Statement of intent. Courts don't require it. Good lawyers sometimes file it anyway so the record has a heartbeat. She asked me to draft it and she'd make it proper. I wrote. Richard Collins intended 3 things. That his wife be housed. That his children inherit the residue equally. That the lake cabin pass to them by 2 without fights. He put those intentions in instruments with stamps. A trust, a TOD deed, pot accounts. We followed the stamps. When something pretended to be a stamp, we brought the real ones to the judge. That is all. Alicia filed it with a short cover note. I imagined some future clerk reading it between coffee sips and feeling for a second like the world could be navigated if you learned which ink mattered. There was a closing Denise had arranged. A quick sale of Dad's pickup to a buyer who turned out to be her sister's boyfriend, with papers she'd signed using the defunct POA. The DMV clerk, alerted by Alicia's letter, flagged the title when the buyer tried to transfer it. A sheriff's deputy called, confirmed the court orders, and the buyer left grumbling about technicalities. I whispered thank you to whoever invented technicalities. 2 days later, the final hearing on our consent orders was set. More form than fight. Still, I ironed my blouse and printed fresh copies of the findings because I like paper that behaves. We'd stand up, say our names, and hear Judge Larkin enter the orders with the weight they deserved. On the way in that morning, I passed Denise in the hallway. She didn't meet my eyes. She stared hard at a plaque with the county's mission statement as if it owed her a different definition of fairness. I didn't say anything. The most satisfying revenge I had left was silence inside a system that had called the facts by their names. When the clerk opened the courtroom door and said, "Collins matter," I stood, took the register of truth because old habits forge new ones, and walked forward. We were done being trapped. It was time to have it entered. When the clerk opened the courtroom door and said, "Collins matter," I stood, picked up my binder, register of truth, and walked forward. Judge Larkin looked exactly as he had the first day. Tidy glasses, a pen that left decisive lines. He'd already read the consent terms the mediator filed, but he made a point of hearing the bones in open court. "Appearances?" he asked. Alicia said her name for us. Mr. Blake said his for Denise. "We're here on petitioner's caveat, temporary injunction and proposed consent orders," the judge said. I've reviewed the hospice records, the notary journal and affidavit, the document metadata and the financial activity under power of attorney. Ms. Gomez. Alicia rose. Your Honor, the parties reached mediated resolution consistent with your prior directives. Petitioners ask you to enter findings voiding the purported Third Amendment for lack of capacity and undue influence, removing Ms. Collins as personal representative, imposing surcharge for misuse of the POA, recognizing TOD and POD transfers, and appointing a neutral administrator to settle the estate in accordance with the 2019 trust. Blake stood tugging his jacket. We agree to entry with one clarification. All parties will refrain from public comment. He eyed me like he wanted to curate my throat. The judge nodded once. Mutual non-disparagement is part of the mediated terms. It doesn't seal the record. Paper speaks for itself. He paused. Court's findings. On the evidentiary record, sedation documented on the amendment date. Notary journal devoid of the act. Creation metadata inconsistent with the notarized date. And financial activity under a terminated POA. The court finds the Third Amendment invalid. It is void, not voidable. Ms. Collins is removed as personal representative. A neutral administrator is appointed. Surcharge of $31,000 approved. Constructive trust imposed over assets transferred under POA. TOD deed and POD designations are confirmed as non-probate transfers. The 2019 trust governs. Ms. Collins retains the life estate in the marital home as written. Petitioners are co-remainder beneficiaries and co-successor trustees thereafter. His pen scratched. The clerk stamped. A sound that should be bottled filled the room, official paper turning into the future. Anything further? The judge asked. Alicia glanced at me. I shook my head. Nothing from petitioners. Blake began to speak then didn't. Nothing, Your Honor. Then we're done, Judge Larkin said. Grief doesn't excuse sloppiness. Mr. Collins appears to have left a map. Follow it. Adjourned. We stepped into the hallway and air I didn't know I'd set aside came back to me. Evan leaned against the paneled wall and laughed once, the surprised kind, then wiped his eyes with the heel of his hand. He said it like Dad, he whispered. Follow the map. Alicia handed me certified copies like medals. Take these to the places that still think they need convincing, she said. Also, go breathe lake air. We followed her first instruction immediately. The bank scanned the order and released the POD claims without so much as a dramatic sigh. The auction house sent a one-line email. Court order received. Sale cancelled. The title clerk at the DMV flagged the attempted pickup transfer as void, post-death POA, stamped our corrected paperwork and slid the new title across. She tapped the judge's order. This is pretty, she said, and I loved her a little for it. The neutral administrator stopped by the shop to walk the floor with Evan. It smelled like cutting oil and patience. Appraisal sets the number, the admin said. The trust gives you first right at a friendly note. He patted the lathe like a shoulder. Make it sing. We spent that afternoon at the cabin because we could. Deputy Ortiz's rekey was old news. The locks turned under our hands like decisions. The lake lay gray and honest. Evan pulled the old tackle boxes from under the bunk. I opened the pantry and laughed at a stack of canned beans my father had inexplicably hoarded. We made a list with real pen on real paper. Recaulk windows, replace step, fix sink board, sand table. The list felt like medicine. That night, I wrote a note to myself I didn't intend to forget. Paper one, not volume. Keep choosing that. Then I slept for 10 hours, which felt like an inheritance in its own right. In the days that followed, the surcharge clock ticked. To her credit, or to the credit of a judge's signature, Denise paid the first installment by cashier's check, a neat rectangle with a name that used to sit beside mine at holidays. Alicia logged it without commentary. The constructive trust account filled from the frozen transfers, then turned and poured back into the estate, money completing a circle it had tried to skip. When the shop appraisal came in, Evan and the neutral administrator sat at the lunch table with a legal pad and a calculator. 10-year note, the admin said, writing, 2% over prime, secured by the machines and a life policy you already have. Evan nodded, signed and slid the pad to me to witness. He ran his palm along the mill as if the machine had a pulse. Turnkey in 3 months, he told me later. You'll hate how early I start, he added, which was untrue. I love early when it belongs to something real. Denise and I had one more necessary conversation. She stood in the doorway of the marital home, arms wrapped around herself even though the heat was on. The life estate paperwork lay on the entry table. Tax bills in her name, insurance declarations with her signature, the maintenance clause highlighted. She looked tired, which is different from weak. I thought he wanted me secure, she said, eyes on the shell dish where Dad used to toss his keys. He did, I said. He wrote it down. He wanted you housed. He wanted us to inherit. He didn't want to fight. I gestured at the orders. This is what secure looks like when the plan is followed. She nodded once, the kind of nod people give when the argument ended 2 rooms back. I won't speak about you, she said, gesturing vaguely at the mutual non-disparagement. I won't either, I said. If anyone asks, I'll say we followed the map. It didn't feel like triumph. It felt like a tensile wire settling into tune. The neutral statement we'd agreed to release read like it should. The Collins family has resolved matters consistent with Richard Collins's estate plan. The lake cabin passes by recorded transfer on death deed to Evan and Mara. Payable on death accounts have been processed. The 2019 trust governs, providing a life estate in the marital home to Denise and naming Evan and Mara as residuary beneficiaries. All parties appreciate the court's guidance in honoring Richard's intent. It used everyone's names correctly, which is a small decency and a big deal. Nurse Joy dropped by the house with a pie the week after the final orders docketed. We sat at the kitchen table, 2 women who had done different kinds of hard work for the same man. I like how the judge wrote it down, she said, flipping through a copy I'd set near the salt. He didn't sermonize. He didn't need to, I said. The facts wanted something specific. Harold invited me over for coffee and showed me the new ribbon he'd glued in his notary journal to mark the day the log mattered. People roll their eyes at my book, he said, tapping the cover. But it's a fence. Fences keep cows in and nonsense out. I brought Evelyn cinnamon rolls with extra glaze. She pretended not to grin and told me the recording numbers for our orders like they were anniversaries. I wrote them in my phone anyway. Mina at the bank waved me to the back, poured decent coffee and said, "Compliance loves this ending." It's possible no one has ever said those words before. Back in my work life, I stood in front of 9th graders and taught them about transitions. We practiced the awkward art of asking for help. One of my girls handed me a college essay draft that used the phrase, "fight for what's mine." I told her about a different verb, protect what's ours, and how sometimes that looks like stamps and procedure instead of speeches and fists. She rewrote the sentence. It was better. At the cabin, Evan and I finished the step and put 1 stubborn screw in a jar labeled for stubborn days. We hung Dad's century-old bobber on a nail beside the door, half superstition, half decoration. We found the index card under the sink I hadn't known about. A second message in that crooked blue. If you're tired, go to the water. If you're loud, go to paper. Dad, I put it in a frame and set it on the shelf with the TOD deed folded behind it, the way some people tuck a saint under a picture. There were ripples, as there always are after stones. A cousin who loves group texts wrote, "So proud of you both," and then in a separate bubble, "Can I borrow the cabin in July?" I sent a polite sentence with a link to the calendar I'd set up because order is my favorite love language. A neighbor asked if we were pressing charges. Alicia had warned me that question would come. No, I said. We pressed filings. That was the point. When Evan reopened the shop under Collins Tool and Die with the sign rehung and the cracked neon repaired, I stood in the doorway at 6 a.m. with coffee and a box of day-old donuts. The first job ticket came from a farmer who'd broken a bracket on a harrow. "Can you make this fit by Friday?" he asked. Evan grinned. "We like Thursday better," he said. The lathe sang. I cried a little for nobody and everybody. On the day the neutral administrator filed the final accounting, Alicia forwarded the PDF like it was a sunset. Numbers aligned, assets where they belonged, Denise's surcharge satisfied, the constructive trust empty because it had done its job. Her email said simply, "Clean file." "Nice work, Mara." I made tea and sat with the quiet for a minute before texting Evan a photo of the line where the cabin didn't appear under trust assets, because it was never supposed to. He sent back the loon emoji and a thumbs up that looked like Dad's hand.